When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
For them to comment on my children is highly improper. And for this court to allow that kind of testimony is also improper. I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it. Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender, Judge.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing you.
Go
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
court's children.
Everyone in this courtroom
just did that. Go sit down.
No one in this courtroom had to endure what we had to endure.
Go sit down.
Mr. Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move to reconsider.
That was their motion.
We have not filed any motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into. You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that.
I would object to going forward anyway right now without the elected county prosecutor who's on this case.
But she chose not to be here.
That's not accurate, Judge.
Okay, okay, your objection's noted.
We had a phone status conference 2 weeks ago in which Ms. Schiff will
Your objection is noted. Okay?
I'm not going to participate in this proceeding without the elected county prosecutor. I think this is a sham that you're going forward. When the court was
You're going to sit here. You're going to sit here.
You were told about her unavailability and specifically told her on the phone not to cancel that appointment, that it wouldn't be a problem.
Well, I'll tell you what. If you want to be here for the decision, that's your business.
Well, Your Honor, I think this is outrageous. You're going forward without the prosecutor.
This court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. He took his shirt off as well. I'm also told that he is threatening to throw and break items. If you don't make a record, then I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
it.
even
Stop it.
letting
You're a
me
public
ask
servant,
the
Your Honor.
questions.
I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All rise for the jury.
Not gonna work. I don't care what you believe fully.
All right.
It's not a game. I don't take this
asked
as a game. That's what
explain
nobody.
this to you
That's what
once
nobody.
again.
You don't gotta explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in
unfair.
this ship
It's
that's going
unfair
on.
and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a joke.
What type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And I
I
understand.
think, Your Honor, with all due respect, I think you should show
we're
some
going to take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in recess.
No, you're not rushing me to judgment. I don't care what you're talking about.
I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said.
That was how I said. You want to run the record back?
Mr. Brooks.
So I'm the only one. I got one. I
Mr.
got
Brooks.
one ear that work, and I heard that.
This
Come on,
is
man.
to benefit
Come on, man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's
has
be clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record
voice
of Abel
just for
Lescott.
that.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value in return for value this document.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opera.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain?
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared.
Juror was in fact served. That juror in fact came in this morning, filled out his questionnaire, and we will schedule them in the panel that they customarily would come for further examination. So that accounts for juror 1157. Or do I have any other inquiry of juror 1157, counsels? Okay, all right. So 1157 will just come in the regular associated panel that that person's supposed to come in on. Okay. Next 2 things are just follow-ups on other business that we held a little earlier. Mr. Menendez, good morning, sir. You were supposed to buy lunch for your colleagues. Have you done that as of yet? You were supposed to have done that by March the 17th. Did you go to, did I told you Jason's Deli? Did you satisfy that prong of your contempt yet?
I don't believe I was.
So when I just want you to pick a date.
Yeah, whatever date is looking for Masons.
Okay, all right. Well, look, I don't have any issue with it. I'm not the person that's going to partake. So it's okay with me. Let me just check right quick.
Also, I never saw the contempt order. I misinterpreted the whole thing.
I have it, and I have. Mr. Menendez, this was in satisfaction of me not sentencing you to jail for 20 days. So if that's the case, well, then I will revisit the basis for your contempt. Mr. Johnson, how are we doing on that paper? I mean, the importance of professionalism. Yours is due by the 28th of April. I'm just checking, I'm just clocking. So we on track? Well, your better half said she's not writing it for you either, because that wasn't offered to you. You've already asked me, could I pay the $1,000? I told you no. Well, I know you would, but that's not what's on the table. 28, yes, at noon. Or you do 20 days. It's 17-page paper on the importance of professionalism in the legal field and treating one's opponents with civility. Paper is to be published quality in APA format and at least 10 primary and 10 secondary sources.
However, Mr. Brums has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat.
Your Honor, I would like the defense to name me one case where Detective Brums has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one.
So, hang on, so would I.
Well,
A case number that occurred in Milwaukee County.
Well, the state hasn't asked for any type of addendum to Mr. Brums.
Counsel, I'm asking.
Well, Mr. Brums is not here right now, but
hang on, counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County, but particularly one that was in front of this judge, then forget it. You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on.
Mr. Brums can testify to the cases that he testified in.
Name a case now.
We don't have those that information.
And he's not
at our
testifying
disposal right now.
Then he's not testifying.
As to that issue, Your Honor?
Counsel, right now, he's not testifying at all because you guys have not given me anything that would indicate he can provide relevant testimony to this trial.
Well, Your Honor, we'd ask that we would have a Daubert motion where he would be able to provide such testimony.
I don't honestly see the point of that.
I mean, he's testified in several cases.
Counsel. He's done it with other judges. Argument does not work with me. Mr. Huebner knows that. Mr. Ahmad should know that. I don't care what other judges have ruled. Period.
Other item had been moved from one place and put in another place.
Objection, Your Honor. There is absolutely no evidence that anything was moved.
That's right. There's no evidence of that. Don't imply something, counsel, that there is no evidence of. None. There's been no evidence introduced in this case by any witness that is even close to that. That assumes facts, not in evidence. Sustained. Move on to a relevant question. Don't imply things that have not occurred and are not in evidence. Move on.
What that judge is, it's argumentative in tone. He's not an expert, and so what one does isn't what we're here to show. We're here to show what he did.
Right, but that's a different. No, Attorney Pattis. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules in all the courts. So, your objection was that it was a motion in limine issue, I thought, that it would require him to lie. I now hear that it's a different objection, that it's speculative, he's not an expert.
I'm waiting to finish so I don't run afoul of your right. I have been in offshore court for a long time. As you know, I insist on making my record, so thank you. And I'm sorry that I stepped on your question. I thought I wasn't done. What I was trying to say was the following. I objected because he's trying to get an evocation in the jury's presence, which is entirely improper, without permission of the court. I objected further because he was asking Mr. Jones a question that places him on the horns of the dilemma. In the course of all of his proffer outside the jury's presence, he's now switched it to one would expect. That is simply not relevant. That's argumentative. He's a fact witness. His state of mind about his conduct is...
I can't disagree with that, so I will sustain the objection. And where does that leave us with respect to possible future invocation?
If there's going to be an invocation, I've requested it prelude to it be outside the jury's presence so that I can argue about whether the plaintiffs are entitled.
All right, so how does that work procedurally? So there's a question. You're going to invoke on his behalf?
I can't do that, I don't think. I'm certainly in the jury's presence. I'll argue it. I'll simply say motion about evocation. Motion about evocation.
Okay. Does that work, Attorney Matty?
Sure, that's fine.
Okay. So if that happens, Mr. Jones, if that happens, just put the brakes on, okay? So she can do it. Okay, let's bring the jury out. I don't know how I'm not making myself clear, and maybe it's my fault. I do not want to sanction an attorney. I do not want to fine an attorney. I have gone almost 2 decades as a judge and never had to do that. And I don't want to do it now. But if we have a continued problem where you're talking over me, I don't know what else to do. I've asked you nicely. I'm literally almost begging you. I have no recourse but to do that. So I'm not asking for your response, but you are certainly welcome to say whatever you would like to say when we're not on the record in the courtroom. That's your right to do so, and I know that you will abide the rules of professional conduct along those lines. I want to just get back and say this. I am responsible for what happens on the record in this courthouse, in this courtroom, and I am not responsible for any other issues. So I don't want to respond to that or go down and address any such statements. I'll start with Attorney Matty. What do I need to do to stop the comments and the call? Just tell me what I need to do. Do I need to hold one of you in contempt? Attorney Pattis? I'm not going to have the comments anymore. I'm not going to have it. I'm not going to have it.
Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen. Can I just say? No, I don't hear because I heard you. Okay, thank you, Judge. It's not. He told the jury it wasn't. It's just not. No, yeah, I objected scope. He said it's the same video. That's improper. And if I'm not supposed, no, it's not. We showed 1E. You're showing 1C. You're showing a different cast. No, but it's not the same video.
It's not the same.
No, it's not. No, it's not the clip that. No, but it's not the clip that I showed. That's the point of scope. And for him to turn around, yeah, I showed 1E. He's showing 1C. It's a different clip. It's beyond the scope. And he's telling me he's announcing to the jury it is. So he runs this courtroom. He doesn't. So I think that the scope objection.
So I am going to overrule the objection, and I'm putting you, both all of you, on notice that I'm not going to hear the comments anymore, the colloquy. Whoever is the unlucky person, that's the next one to do it.
Well, the next time it happens, I'm going to ask to approach then and ask for an admonishment of counsel because I am not going to take it.
You're not getting the last word in here, so I would suggest you stop. I will say again, the next person who does it will be on the receiving end of a contempt hearing. That's it.
Excuse me, Your Honor. I have a proposal not related to this.